Good morning. How's everybody doing today? I was gonna by default say Tuesday, but it is Wednesday. Well, this morning and today is January 21st. Welcome to the First District Court of Appeals. We have, let's see if I can count here, we have 7 cases on the docket this morning. All but the last 3 have submitted on the briefs, so I'll be calling the entire docket. And attorneys know when you hear your case, state your name and your readiness to proceed. All right, so the first case is C250036 in Ray JL, and that has submitted on the briefs. The next case is C250397 James Mitchell versus Ronisha Haggard, and that has submitted on the briefs. Next one is C250220, State of Ohio, Lamorsis, I know I didn't get that right, Johnson. The next one is C250308, State of Ohio versus Conti Jones. And now we have the ones that are going to be arguing this morning, C250277, State of Ohio versus Carlos Tompkins.
Judge Thompson on behalf of Mr. Tompkins, ready to proceed.
Good morning.
John Young on behalf of the State of Ohio.
Good morning. C250384, State of Ohio versus Mark Beckholt.
Michael Trapp, appellate, ready?
Good morning.
Scott Heenan on behalf of the state, ready?
Good morning. And the last case we have is C250361 in Ray SH.
Good morning, Your Honor. Brian Goldberg on behalf of SH. I am ready to proceed.
And Ron Springer on behalf of the state, we're ready to proceed.
Okay, wonderful. All righty. Good morning, Attorney Thompson. How are you doing?
Good morning, Your Honor. I'm well. How are you?
Good, good. I don't think we've seen each other since this year, right? So
No,
Happy
not
New Year.
yet.
All right, so Happy
This
New
year.
Year.
Happy New Year to you.
Good, good.
The schedule
Alrighty.
on here looks good. I'll reserve 5 minutes.
All righty. Whenever you're ready.
May it please the court, counsel. This is a case about the restitution amount, as Mr. Tompkins pled to this case, but our argument is that the trial court erred and abused its discretion by ordering the restitution amount of $6,341.43. That argument is based on the inconsistency of the trial court's evidentiary ruling, essentially, because it didn't really make a lot of findings, but it did ultimately make a ruling that for these purchases from the Mad Tree Alcove and the Copa Lounge, that the text messages were essentially enough evidence that those were business or related to the foundation. But is there anything different about a lot of the other purchases? And our argument is there's not. The trial court made these removals because of these text messages and that the purchases came up for that Copa Lounge leading up to that alumni weekend. But here from the defendant's exhibits, we have a number of text messages. Defendant's Exhibit B regards a $100 withdrawal for a Hughes Organization alumni luncheon. Defendant's Exhibit C involves a $260 to pay people who had worked at the Bengals game. I'm sure the court's familiar. They had this situation where they didn't have enough people, and apparently the Bengals apply a penalty if you don't have enough people to staff the concessions that you agreed to do. So he agreed to pay everybody the full amount they would get if they came. Defendant's Exhibit D was $300 to get his car out of impound. That is, probably one of the more attenuated things, but ultimately Mr. Tompkins, in this case, he's the president of this foundation. He needs a car to do the business of the foundation. So there is at least a connection between the car and business of the foundation.
Can I go back to the concessions at the Bengals game?
Mhm.
There was at least one transaction that took place in May during the Bengals offseason. Is that correct?
Yes.
And how was that consistent with paying these concessionaires during Bengals games?
I don't recall the specific purchase you're speaking of, but I do recall there were concessions at the Reds games as well, so maybe that was it. If you give me do you know the specific one? I could look at it.
No, and I didn't see any reference to Reds games being involved in the
I know
concession deal, but
Miss Ward testified that she had gone to Reds games, but I do think most of the discussion was about Bengals games.
The two that the court did allow were Copa, what was the other one?
Mad Tree Alcove?
Was there anything different that was in the record regarding those two in terms of either his explanation or the foundation witnesses' testimony about those two expenses?
So,
Because
Yes-
it
yes
seems
and no.
she credited those two, the judge credited those two, and
yes.
did not credit the other. And it seems like the court was given a great deal of information over an extraordinarily long restitution hearing.
Right. Ultimately, I don't think that there was, but the difference, I suppose, the state would point to is the lead up to this alumni weekend and sort of, I mean, I'd point to maybe perhaps some recency bias as well. They were closer in time. But,
So the court found those legitimate. Would you agree that the court was, based on the testimony and the information presented, was free to believe or disbelieve the witness presented by the state?
sure. And this isn't really about a credibility issue so much as it is about equally or not as an abuse of discretion, equally applying the same sort of evidentiary findings or standard, for lack of a better word, to the other purchases as well.
But it's really not about evidence. All this information came in.
Right,
She just determined that, for whatever reason, really not stated on the record, but perhaps borne out by the records, those two expenses were more credibly related to the foundation's business than the other expenses. It's not an evidence issue.
well, I'm with you till the very end. The credibility problem, I don't agree with, because the court didn't say. And my position is essentially that these other purchases had the same amount of proof that those purchases did. So the court was right to exclude those purchases from restitution, but the other, I think I counted up $1,191 at least.
So as to the remainder, though, you would concede that that restitution was due? The total amount is something like $6,000. You're basically saying the court should have discounted an additional $1,100, plus or minus?
Yes, plus at least another $1,500 because of the dispute over the rent. There was no finding made there. I know there was a dispute in the evidence about whether the rent was for Mr. Tompkins or Mr. Carr. So that gets us to another $3,400.
Does the trial court have to make a finding on the record in regard to that particular issue, or simply listen to and parse the evidence?
Well, I don't know that they have to make a finding, but we are reviewing it for an abuse of discretion, have nothing to work with. You know, it's,
Well, we have this, I mean, you'd agree, it's quite a restitution hearing.
yes, 2
So
days,
it's a lot.
right.
And the court sat through all of that and was able to look at, listen to, and make judgments regarding the witnesses that were presented.
It reached a conclusion in the restitution ordered, but I would say that a long 2-day restitution hearing also merits some specific findings, given the amount of different purchases and the amount of money involved here.
But there's no obligation, for example, to have a written decision or a finding of fact. The court could come to a general conclusion regarding restitution.
Yes, but when we're looking at for an abuse of discretion, we have this question of essentially equal evidence, two different people testifying, no finding that one person was more credible than another. In fact, the only findings we have is perhaps that Mr. Tompkins was more credible as regards the alcove and the COPA purchases. So in terms of equally applying, is there a preponderance of the evidence? At best, we've got a tie on these disputed evidentiary issues, and that's why I'm saying we just don't get to that 50.1%. So to wrap things up,
So what is it that you believe that the trial court should have done? What is your position on that?
I don't think it was required, but I do think it should have made specific findings about the amounts in question here, because
So while it's not required, then why is it that it would be error?
when you make findings to disallow some of the restitution, it calls into question the application of the evidentiary findings as regards the other cases. So basically.
So what if the state had filed a cross appeal
For more restitution,
for saying that the exclusion of the two items was incorrect?
then I suppose they wouldn't have to argue the rest was, but if the court granted them leave, then I suppose they could, but they didn't.
Well, I know that they didn't, but this is a hypothetical. What if they had filed a cross appeal? Your position is the exclusion of two in light of the others is where the error lies, and their cross appeal would say the exclusion of the exclusion of two, it's the same but with a different result, right?
Yeah, but I also think they'd kind of be making my point that, when you exclude all of these others that have the same sort of evidence and nothing really calling that into question, that the court abuses discretion because the state never met its preponderance standard here.
Because I think the bigger problem is, what if you didn't file an appeal and they filed an appeal and asked for leave, got leave, all that stuff, and it's simply on the restitution saying that it should have been greater because it should not have excluded the two?
Well, I would have the same position
I don't think
have
that you would
now.
acquiesce. I think you would probably talk about credibility determinations and such.
I think I'd say the same thing now, that the two that the court excluded were correct, and that this court shouldn't grant the rest because they had the same burden of proof as the two that were granted.
Did you see what the problem was? And I'm trying to understand, it's an abuse of discretion, right? So under the abuse of discretion, what is it that makes this error, using the language of abuse of discretion?
Well, you're making a good point with the competent, credible evidence.
Because I think you have a competent, credible evidence issue. The other, I was thinking, is he trying to say it's capricious? Is this sufficient for it to be capricious? Capricious is a very high standard. So there was two things I was thinking of.
Yeah.
You got, that was one.
Arbitrary. I would say arbitrary and
Okay.
capricious. Those are the two words that go together. I
Okay.
would say arbitrary.
All right.
Because there doesn't seem to be any real standard that makes sense why these were different than the others.
All right. All right. Thank you so
Thank
much.
Morning, Your Honor.
Good morning.
Just a statement to start off by saying that under the abuse of discretion standard here, clearly there was no abuse of discretion. To have an abuse of discretion, the result would have had to have been arbitrary or unreasonable. And I think, as Judge Nestor alluded to here, we had
Or capricious.
or unconscionable, I think the word is,
Is it
actually.
a-
Arbitrary,
okay.
unreasonable, and unconscionable.
Okay.
So we had a 2-day restitution hearing here. The state put a ream of evidence into, a ream of records into evidence regarding about 70-some transactions, most of which could not be accounted for. You had the state's witness, Ms. Ward, indicate that these payments were pretty much all unauthorized, that she had asked Mr. Tompkins, where did this money go, that he could provide no accounting for where this money went, that he dissembled on a lot of it, that he promised to pay some of it back and never did.
What did she have to say about Alcove and Copa? Did she concede that those were legitimate?
I believe that basically the testimony from the state's witness, Ms. Ward, on that issue was that this was basically a meeting to plan the gala, and that the Copa transactions were for an after-party after this gala. And I think the trial court ultimately determined, after hearing all of this, that the state and the defendant's evidence squared on this issue, and that they were in alignment. And that
Was there any similar testimony regarding any of the other unexplained
Not to my
expenses?
recollection, Your Honor. So I think that's what distinguishes those two payments that the court discounted from the total restitution figure from all of the other figures that Mr. Tompkins is requesting that this court should add to, or I guess subtract from, the restitution order. But ultimately, at the end of the day, there was nothing arbitrary or unreasonable about the restitution figure that the court ordered. I mean, clearly it heard a lot of evidence. It clearly considered everything.
Well, the point, as I understood the argument, is that all of the restitution items were equally situated as far as the presentation of evidence. And
don't agree with
so
that
there was the differing of the treatment of these two items was, I'm going to say, incongruent, instead of using the language of abuse of discretion. But what I'm hearing you saying is that there was more testimony that provided more information and gloss to those two items?
But what I'm saying, what distinguishes those two items from the other items that the defendant, Mr. Tompkins, is complaining about here, is that on those two items, everyone's testimony seemed to line up on the issue of what that money was used for. And ultimately, the trial court made its determination that, well, there's a colorable argument to be made.
And that was my other question. Did the trial court say that these two payments were legitimate, or did the trial court say that, in essence, that it could have been legitimate? And there's a difference there.
Sure, but I think ultimately, if it was taking those
I think there's a
payments-
difference there because of
sort of the
treatment.
The proof is in the pudding, right? I mean, if she's removing those from the restitution order, she's clearly making the determination that that was at least somehow tenuously related to, or not even tenuously, relatively related to foundation business, right? You're talking about a planning meeting for this gala, and then you're talking about an after-party where there were a bunch of alumni present.
I
So
just
you can
realized
make
I didn't hit the thing for you, so.
Oh,
But that doesn't mean you
all right.
get extra time.
But the thing is, this goes to the defendant's point, it would be helpful if we actually had the, kind of a line by, not line by line, but category by, like an explanation. The explanation as to these two
Sure.
expenses is, in contrast to the length of the hearing, is rather minimal.
It is, admittedly, but ultimately here, we're trying to determine whether it was arbitrary and unreasonable, and I think the record is sufficient to bear out what happens here, right, what happened here. A lot of these transactions were at gas stations. There was one up in Wapakoneta, Ohio. I had to look up where Wapakoneta is. It's
It
up by
exists.
Lima, Ohio. It's
Home of,
a long, long way away.
home of Neil Armstrong.
Well, learn something new every day, Your Honor. But I digress. I mean, there was stuff in Hebron, Kentucky, there was Mason, Ohio, Lebanon, Ohio. There was no explanation for how most of this stuff was, related to Hughes Alumni Foundation business. You've got the $1,500 dispute. That's clearly a credibility determination. That's a straight-up credibility determination.
And, to Mr. Thompson's point with regard to whether there needed to be more discussion from the trial court supporting the outcome, the way I look at that is a potential request for a remand, and we certainly sometimes remand if we cannot have meaningful review over the appeal in front of us. So we remand not for a new hearing, but for the trial court to provide more guidance, more information, so that
Findings
we
of
can
facts,
have.
conclusions
Yeah,
of
so that we
law.
can have. So explain to me why that particular argument is, I don't think you're going to agree with it, so why you would say that it is flawed?
I think we have just such a good record here, Your Honor. I don't think it's necessary. I think you can glean what the trial court's, thought process was here, even if it's not explicitly stated in the record. We had basically conflicting testimony on most of this stuff. You have a very robust record in this case. You've got Mr. Tompkins' testimony, which I would submit was not particularly credible. And at the end of the day, clearly the trial court concluded that at least on most of this stuff, at least where the testimony didn't jibe, she just didn't find Mr. Tompkins particularly credible, and she was willing to credit the state's witness, got out her ledger, her abacus, determined that there was some congruence on some of these payments, and then deducted them from what the state's total request was relative to all these transactions in total. So,
And that's kind of a risk that goes with committing crimes like this, right? I mean,
well,
if you do that kind of crime, maybe the numbers aren't exact, but
Mr. Tompkins, had a fair opportunity, more than a fair opportunity. He had a two-day restitution hearing. I don't think I've ever seen a restitution hearing this robust. Had every opportunity to provide an accounting for where all this money went, and he really didn't, at the end of the day, do that. So,
In a way, the fact that she actually made those two deductions proves that she considered the entire.
absolutely. She was not just taking the state or defender or either party just at their word. She clearly considered everything that was in front of her and made a determination about what the appropriate figure was based on, really getting down in the weeds and looking at the evidence. So, when the standard is abuse of discretion, I don't think there's enough to reverse here. I don't believe a remand is necessary, so we would just ask the court to affirm.
All
Thank
right,
you.
Thank you.
I just say very briefly that.
I want to explore the idea of the remand, if you don't mind, okay? Can you please, share your position on perhaps why a remand would
it
be
would-
merited in this case?
It would certainly.
Because what you're talking about, as far as your part of the argument with regard to that there should have been more discussed, that's really more about a remand than finding reversible error.
I would generally be okay with a remand, but I think I know what I'm asking the court to do is to review the evidence and see if the trial court abused its discretion.
I hear two arguments.
Right.
Okay? So I just wanted to explore the remand part of it.
Well, it's better than losing for us.
No.
That's our position.
Okay, what I'm trying to say is why, give me your position on why there should have been more, right?
Mhm.
And so if we were to determine that there should have been more, that would be a remand, right? So just give me your best argument on why there should have been more.
It has essentially made
Because
the
what I heard
parts
the
that were
state is
denied-
that there was testimony that lined up on these two items, and that wasn't had on the other items.
The lack of findings has made review very difficult. That would be my position. So if it was to support a remand, it would be because we don't have anything from the trial court to help us understand what these other purchases or withdrawals, what made them different.
Compare that to a trial, a bench trial. A trial court finds just generally, right, guilty or not guilty. This is something less than a trial, yes?
Yes.
So why should a court have to do more?
Well, my point wasn't to ask for a remand, but, and I'm not saying they have to. I think I conceded they don't have to in my opening, just that more would have made it easier. And here on this record, where upon review, the ones that were granted or restitution wasn't granted, I guess I'm trying to say, our position, and I know there's been questions about if they're different, our position is they're not. They were meetings at restaurants, there were Mr. Tompkins' testimony that buying gas to go to foundation business, and I think even Mrs. Ward said at least once she bought gas and didn't pay it back. So, the other thing I just want to point out is that it's the state's burden. Mr. Tompkins didn't have to bring anything. They brought some things, so Mr. Tompkins testified and he put on evidence, but ultimately did the state prove by a preponderance of the evidence that this restitution was owed, that there was an economic loss. And there was no evidence that this wasn't for Hughes Foundation business. So our position is they didn't meet their burden, and the trial court abused its discretion in inconsistently, that's the word I was looking for before, applying an evidentiary standard here. If there's no further questions, I think and ask the court to reverse.
All right, thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a nice, warm, safe afternoon.
You too.
I think I heard rumor that there might be snow coming. Yeah, all right. Good morning, Attorney Trapp. How are you doing?
Morning, Judge Sykes.
Happy New Year.
You too. I'd like to reserve 2 minutes of my time.
Okay.
for vote, please. Hey, please, the court. The trial court here, its judgment is not supported by sufficient evidence. Its judgment deciding that Mr. Beckold had violated the terms of his community control is not supported by sufficient evidence. Because the community control violation said only that he was unsuccessfully discharged from River City. It didn't state the grounds for the discharge. So the trial court knew his discharge, and Mr. Beckholz admitted to that by his no contest plea. But he didn't give the trial court any grounds that were his fault. And that's important because the rule, I think, that should come out of the case, and that the rule that I cited from the 12th District is that there has to be some fault of the defendant in River City.
What was the language in the community, in the rules for the community control with regard to River City?
The defendant was unsuccessfully discharged from the River City program.
No, I mean, you know, when they, there's going to be a signing of the rules for community control, and in there it said something about River City, about engaging with River City. What was the language therein?
It's not in the record, as far as I know. That's not in front of the transcript. Wasn't
Okay.
filed in a case.
And the document of the rules for community control was not made part of the record?
No.
He was not required to successfully complete the River City program?
He was, and he didn't do that. But the reason he didn't do that wasn't in the violation and not admitted by the plea.
Well, was there a colloquy after the acceptance of the no contest during which there was an explanation? Was the defendant given the opportunity to explain why he failed?
He was. But before the plea was accepted, his trial counsel pointed out that Mr. Beckold has a bipolar disorder, that he was off his meds, and that he was given the wrong medication at River City. And the trial counsel said, I don't believe this is something that was totally under his control. I have it written down here.
And that was before the plea.
Before the plea.
But then the court accepted the plea, which was kind of bare bones in its explanation of, or it actually excluded this information about the mental disorder. And in effect, he was given the opportunity to explain the circumstances of his discharge, yes?
He did, and he explained that he got the medicine for the guy behind him in line or in front of him in line. He explained that. He got the wrong medicine, and that caused him to have a mental breakdown. He went to UC Hospital.
And at that point, he was unsuccessfully discharged.
The institution decided to discharge him, yes.
And then the trial court would have been putting him probably back in the jail, yes?
Well, I'm not sure your question. The trial, he was unsuccessfully discharged, and the trial court decided that that was a violation of his community control, without knowing why he was discharged, just knowing he was unsuccessfully discharged.
So what were the alternatives for the trial court at that point? The trial court knew that River City was not working, yes?
Yes. River City didn't want him, let's put it that way, because they unsuccessfully discharged him.
And then the alternative was more likely either keep him in the county jail or decide to impose a prison term.
Well, the trial court has to decide first whether he violated the terms of community control, and then whether that community control should be revoked. So there's alternatives that the trial court can do if it decides to revoke his community control and impose sentences, prison, jail time, something else. But it doesn't have to. But before we ever get to that, there has to be a substantial basis to believe that Mr. Beckold violated the terms of his community control. And his plea here, his no contest plea, did not admit that, because the rule is it has to be something that's under his control for him to be unsuccessfully discharged.
And so where do you get that rule?
Out of the Noonan case, out of the 12th district, which is cited in my brief, and also by the inverse of some of the first district, one of the first district courts was like, I think it's Elliott or Richard, I cited two of them, where if it's under your control and you're unsuccessfully discharged because you're inappropriate, you fight with them in there, you disparage their program, you say you want out, that's something that's under your control, and this court has approved of that from people not unsuccessfully discharged.
So is the under one's control, is that an affirmative defense or is that an additional element? How would that be properly treated?
It's part of the burden that the state has to prove in order to show that he's violated his community control. Not just that he was unsuccessfully discharged, but also that it was something that was his fault or under his control.
So what you're saying is the case law has treated that as that sounds to me like an additional element. It might be a silent element, but an additional element maybe created by case law that the state has the burden.
Yes, the state has the burden, and
In order for the state to have the burden, that means that it's treated like an element.
yes,
Okay.
the unsuccessful discharge by itself is not enough, and that's all the trial court knew here by the plea. The other information that it had was that he was given the wrong medicine. That's something.
I
not
hear
in-
what you're saying, but I'm trying to understand how to look at this, okay? And I just want to make sure that I'm understanding what you're saying correctly, that the state has the burden, so this is akin to like an additional element, maybe created by case law, right?
I think that is correct, that the state has to prove that the discharge was at his fault. And usually
And I'm
that's
not,
very easy.
I'm not trying to, I don't disagree or agree with you, I'm trying to get to the right answer, Attorney Trapp, okay?
That is exactly what I'm
Because-
arguing.
So
Okay,
it-
because
it-
if that's the argument, then, okay, then I understand. Because if it's not an element, then it becomes curious to me as to why plead no contest as opposed to taking it to trial in order to establish that it wasn't something out of his control. Do you see the difference? If the state has the burden, then I can see perhaps that it would be handled at the juncture that it was, possibly. But that seems awkward to me, because now the state is supposed to bring evidence after a no contest plea, which seems like a due process issue for your client.
So I don't fault the trial counsel here, because I've been in that position many times, and your client was unsuccessfully discharged. That's truly happened. He can't contest that.
So why wouldn't it be handled in asking for a hearing in order to bring in evidence to establish that, and to be able to establish that while he was discharged unsuccessfully discharged, but it was actually not in his control?
He could have done that, but you have to understand that there's many of these probation violations hearing it every day. Without a hearing, they're resolved, most are resolved by plea.
I understand,
Actually,
but,
trying not to put the trial court through extra work.
but
Yes.
aren't you asking almost for like a due process issue if it's going to be addressed pursuant to a no contest plea, and then there's going to be evidence and discussion and whatever, and then the trial court is supposed to, at that point, determine whether it was under control or not under control, as opposed to it going to a true hearing? where there's going to be rules of evidence and all of these protections, I'm trying to wrap my mind around this, especially the juncture of it is what's really troubling me the most.
Well, look, there's no question he's unsuccessfully discharged. There has to be more than that, and that's the
Well,
rule.
so if there has to be more than that, why wouldn't, and I know that there are many of these, but in the circumstances where the client says, I was given the wrong medicine, and the counsel knows that, why not just plead not guilty and then assemble the people to explain that to the court?
Well, the trial, you could have done that, and it had been a better record for us if he'd done that, and it might have been a better resolution for Mr. Beckold here. But he was unsuccessfully discharged, and that was,
Well, I know, and that's all the violation says. It doesn't
Right.
say unsuccessfully discharged because he failed to take medicine because it was a mistake that was made by the, but if you wanted to put all that in there, you could just say, not guilty, state you're not meeting this element of fault.
you could have a hearing, but I know I've done many of these probation violation hearings, and I shouldn't say hearings, probation violations, and I've had a hearing maybe once. It's just, and you don't want to anger the judge by having, turning a busy docket, you don't want to have hearings on everything. He could have, but he didn't do it here. But I'm saying he didn't need to. The no contest plea to the unsuccessful discharge is not enough. And when the violation doesn't say something that alleges that it was the defendant's fault, he can plead to that,
So you're,
because that's not enough.
you're saying the probation violation had to specifically say that the reason he was discharged was not related to anything he was in control of,
It just said he was unsuccessfully discharged. It
Which
didn't
is-
say why.
which is on its face a violation of the terms of his probation, which required him to be successfully discharged.
Okay, I don't think that's right, because that would turn going to River City into a game, and I put that in my brief. It's a gamble for you. If you go there and you get discharged for any reason, they don't like your looks, you talk back to somebody doesn't like you, you get in a fight and you're self-defending yourself and they throw you out, or maybe you get the wrong medicine, or they decide they don't want to treat you. That would turn River City into a game, and we don't want that.
Well, I think that would also encourage people to plead not guilty, and as Judge Nestor pointed out, fight those facts on the record. Here, he pled no contest, which is an admission to the facts and the violation, as I understand it.
He admitted the facts, those are true, he was
And the fact-
unsuccessfully
The fact in the
discharged.
violation was that he was unsuccessfully discharged,
No question.
and his probation required him to be successfully discharged.
Yes, but he can't be discharged for a reason that is not his fault.
And if he felt that way, he had options.
His counsel could have had a hearing and done that, but he didn't need to here because he admitted he was unsuccessfully discharged, but then he explained to the judge before the plea,
Well,
Judge,
so,
he
but
got the wrong
that
medicine.
explanation was kind of like his view of the event. The other option is the court could have accepted the no contest plea and set this for a sentencing, 7 days later, and the people from River City could come in and explain it and give the River City side of the, right?
Court could have done that if it had, I don't think this is a violation of community control.
And
I wanna hear
oftentimes,
from
they
River
just get
Cities.
continued, right?
Many times they get continued.
But in this case, the trial court had already warned the defendant that it was his last chance, yes?
I believe they did that, but none of that is material here when the violation is unsuccessful discharge, when he doesn't have the reason to know why he was unsuccessfully discharged. That would be, you just go to River City, and if you get kicked out for any reason, you lose.
But those violations say that all the time, don't they? They say it. They say without explanation, unsuccessfully.
It's very common.
Yeah.
Sometimes they put in why. And, he got in a fight and it's his fault or something, but sometimes they just say this. And so you probably think as a trial counsel, I'm going to plead no contest because he was discharged, but I'm going to explain why and hope the trial court accepts that explanation. I'm
And
saying
the
that-
court in this case could have accepted that explanation and simply sent him back to River City, continued his probation.
Yeah, I'm out of time. True, Judge. He could have continued if he wanted to. And I haven't got to my second argument, but I'll stop. Thank you.
Good morning.
all this talk about whether or not the violation was something that was under Mr. Beckholt's control, something that was definitely under his control was his choice to plead no contest. And not just to plead no contest, but to waive reading to those violations and to stipulate to both cases.
Well, isn't that kind of like it's almost like the litany, right? It just happens all the time like that.
Sure.
Just the probation violation is like this, and then it's just almost like a litany of things that people do. It's part of a script.
True, but that's like saying that most cases end in a plea, but there's nothing wrong with that. That was Mr. Beckholt's choice, was to plead no contest, and if he felt
One
that,
thing that I found interesting was that he chooses to plead no contest, and I understand that this is common, right? But now he's talking about some very significant and persuasive facts on why he wasn't able to successfully complete, right?
he's
So,
talking
my,
about this.
and I know this isn't raised as error, but I found it interesting that the trial court just plows forward and just continues to, and makes a determination as opposed to saying, well, wait a second, perhaps you would like to have a hearing on this.
Again, if Mr. Beckholt wanted a hearing, he could have asked for it.
No,
And
what I'm
all
saying,
the-
but I hear what you're saying, but the trial court is now being presented with information that, where the trial court is being asked to make a credibility determination and to make findings of fact that is outcome determinative as to whether Mr. Beckholt should be found to have violated his community control, but continued, as opposed to taking a step backwards and saying maybe we need to have a hearing on this.
And again, that's something, if Mr. Beckholt wanted to, he could have asked for that, and I believe he would have gotten it. But when we look at what he did present, we have Mr. Beckholt's side of things. But the things that's all we have. And it's not that these are things that would not have been documented. He talked about going to University Hospital. There would have been records of that. He talked about there being a medication mix-up. I assume there would have been records of that. He talked about filing a grievance against a nurse. There would have been records of that. There are records of all these things that he could have brought in, he could have presented either at the violation hearing or at a subsequent hearing to, a follow-up from the determine whether or not he
Let's
should
say
be
he had brought
violated.
all of those things in. Is this the right juncture to be bringing those things in?
When else would he bring it in? I mean, he
At a
could have pled
hearing.
not guilty and brought those things in and say, hey, this wasn't under my control. They gave me the wrong medicine.
Say-
That wasn't my
I'm sorry,
fault."
if he pled what?
He pled no contest.
Right, but I thought you said if he had pled not guilty.
If he had pled not, I'm sorry, if he
Yeah.
had pled not guilty.
Yeah, so he would have had a
challenged
hearing.
it And brought those things
He
in.
would have had a hearing, exactly.
But like in this circumstance, this probation violation is a hearing.
Yes.
And if he wanted to, he could have brought whoever he wanted to for the sentencing portion of the hearing.
He could have, and if he
And-
didn't have
but
them
on
available.
the same token, he could have, or the state could have, asked for a delay so people could be assembled to present that evidence like a week later.
Well, after he pled no contest, at that point, I don't know that, at that point, he's offering essentially mitigating evidence, and that would have been on him to present, not on us to.
And
give
that
him
was a
time to
question
do it.
I wanted to ask, but we went down a different, when I was asking him, is this an element or not an element? Because is this being presented in mitigation? Or is this being presented for determination on the merits at this juncture with a no contest?
Here, it would have been a mitigation. The way this the way this case went forward, this is mitigation. He didn't say that he didn't violate. He wanted to then go and explain why, and the why was in the mitigation, that the why was it wasn't my fault, that it was all these other people's fault. And all he had was his own word on that. He didn't, and these again were things that, records of what he complained about. They exist somewhere. He could have brought those in.
So this is a credibility determination.
It's a credibility determination, and it's also an evidentiary one. I mean, he presented nothing to support him,
Other than his testimony.
well, other
which,
than his testimony.
If the trial court chose not to believe his testimony. then-
Correct.
But is it testimony in mitigation? Is that considered testimony?
It's not really testimony, it's not sworn. I mean, it's what
That-
everybody offers at sentencing.
Again, it brings me back to, is this an element? Is this, is this mitigation? All of that stuff. Because the arguments are basically premised as if it's not mitigation.
I'm sorry.
It's the way I'm understanding the argument is as if it's premised, as if it's not mitigation, because the state had the burden to establish that it was not in his control. Those are not arguments that go to mitigation.
Again, I don't know that there's any case law from the first district that says that, but if he wanted to bring that up and said this wasn't in my control, he could have pled no, instead of pleading no contest in waiving and stipulating, he could have said, no, I'm not guilty. I didn't, that was out of my control. He could have done that. He could have done that, but he didn't. And, you know, to whatever the state's burden, he took it away when he pled and waived and stipulated. So sure, we obviously have a burden in a community control violation to show that the violation happened. And if you want to add that we have to show this, that it was a factor within his control like the 12th district has, this isn't the case to do it. Do that in a case where the person pleads no, not guilty, and we actually have that hearing. But in this case, he pled no contest. He took the burden away from us by admitting and
And
stipulating.
remind me, the
and then
12th
tried to
district
explain
case, was
away.
there an actual hearing with testimony on the merits as to whether it was in his control or not? Or
I'm
was
sorry,
that handled
in the
in
12th
mitigation?
district?
Yeah,
I don't know.
okay.
I don't know. Maybe Mr. Trapp does, but I, off the top
All
of my
right.
head, I
In
don't
the
know.
testimony, from your perspective, or not the testimony, in the defendant's statements, did he admit that he was off his meds?
He said he was given the wrong meds.
But prior to being given the wrong meds, was there ever any statement that he was off his meds? That's in the record.
I don't recall. I don't recall. I just remember him saying that he was given the wrong meds, that this caused him to have some type of a medical issue or a psychological issue that led him to going to University Hospital, and that he had filed grievances against the nurses at River City. So, again, at the end of this, he was the one who was in control of his plea. He pled no contest and waived and stipulated, was found guilty, and the trial court just didn't believe his mitigating evidence. And that's an abuse of discretion standard at that point, and there's nothing in the record that shows the trial court abused its discretion, so I would ask that you affirm.
Thank you.
Well, I have limited time, but I think the rule that should come out of this case is that when you have a probation violation that says he was unsuccessfully discharged, there has to be more. It has to be, show that he was discharged for some reason that was under the defendant's control. And that would make it a much better administration of justice in the common police
The
court.
12th district case, do you recall whether the determination that it wasn't in the accused control, whether that took place pursuant to a hearing, or did that take place during the mitigation phase?
In the Noonan case from the 12th district, I think it was a hearing. I'm 90%
Okay.
sure, but I don't remember. It's been a long time.
Okay.
I looked at-
Because it seems to me, and I fully understand your argument about under control, Attorney Trapp, okay? It seems to me that the under control is really a subset of knowingly. In order for you to have violated your community control, you have to have knowingly, and if it's not something not under your control, then you didn't knowingly do it, right? But if you weren't taking your Medicaid or whatever, then that takes it into a different place, right?
Right, he didn't violate his community control terms if someone gave him the wrong medicine.
Exactly. So, I think you're hearing where I'm trying to figure out here. It's like, where is the proper presentation of this? Whether, because knowingly, it really is something that gets presented, it seems to be more in a hearing than in mitigation.
I think it's an element of the defense that the state has to prove, and the court would clarify justice by saying that just unsuccessful discharge is not enough. There has to be something alleged or something pled to that it's his fault. And that would make life easier there in the court of common pleas. I didn't even get to my second assignment.
Do you want to get to the second argument? You're
I
welcome
I
to.
just want to make a little bit, it's an abuse of discretion, it's unreasonable, and it's arbitrary. When the only information the trial court has before it is that Mr. Beckel was given the wrong medicine, and then to revoke his probation on that and send him to prison, that's unreasonable, and that's an abuse of discretion. Either one of these, his prison sentence should be reversed. I'm asking you to consider reversing on both, but the first, to me, is where the decision should be here. You don't get to the second if the first is decided, but there's a rule that should come out of the case, which is just these, he was unsolicitedly discharged is not enough. There has to be more. I would ask you to reverse on that. Thank you.
All right, thank you. Thank you both. Thank you both for your arguments this morning. We'll take the matter into submission and issue a timely decision. I hope you both have a wonderful week. All right, the last case we have this morning is In re SH. Good morning.
Morning, Your Honors.
Would you like to reserve time?
Reserve 5 minutes, please.
All right.
Your Honors, good morning. May it please the court, opposing counsel. The only issue in this appeal is whether at trial the state of Ohio established that the offense occurred in Hamilton County, state of Ohio. I'm not raising any other issues. That's the only issue that I raised in this appeal. And in the trial court's decision, in the magistrate's decision, she relied heavily on the fact that during the testimony, this was a failure to comply. The juvenile had, I guess for lack of a better word, led Indian Hill Rangers on a chase through Indian Hill. There was an accident, and during trial, the prosecutor showed a Google Map image of where this accident occurred. It was at a lodge, and in the top corner of this printout, it said Cincinnati, Ohio, and that was one of the points that the magistrate really focused on in finding that venue occurred in Hamilton County, state of Ohio.
Was the Google map admitted?
It was.
And did it demonstrate that the location was in Indian Hill?
It just said Cincinnati, Ohio.
Did it show the actual streets?
I don't believe it showed streets. I think it was just a picture. If I recall, it was just a picture of this lodge where the car ran off the road and hit this lodge. I don't recall if it was I think it was more of a photograph from Google Maps. I don't recall if there are any streets on the map. I think it was just a photograph, but it did say Cincinnati, Ohio on top of it.
And was that presented at the time that Officer Camardo was testifying?
Correct. That was during his direct examination.
Okay. And he then testified with regard to different roads?
He did testify to different roads
And
that,
even like the Little Red Schoolhouse?
he did, that is
And marks
correct.
and so on, okay.
That is correct.
So how is it that that's not sufficient, the testimony, the Google Maps saying Cincinnati to show the roads, and why would that be insufficient? for venue?
First, as it relates to the Google
It may
Map-
not be ideal, right? It may not be the way we would want things to be done, but why is that insufficient?
As it relates to the Google Map printout, my first issue is this did not occur in Cincinnati. This was in Indian Hill. And I raised this in my objection to the judge, that just because something has a mailing address of Cincinnati does not mean that it is in Hamilton County. You can, and the specific example I gave in my objection was, if you go to Eastgate and you go to the Best Buy store in Eastgate, they have a Cincinnati mailing address, but they are located in Claremont County, Ohio.
Is Indian Hill the jurisdiction exclusively within Hamilton County?
Your Honor, I believe it is. I don't get out there that much, but I know it does border or come very close to Claremont County in certain parts of it. So, a lot of the cases that address, certainly from this court, that address venue, there have been cases where roads are mentioned, and then you have testimony from Cincinnati police officers or Cincinnati detectives.
Here, did Officer Camardo testify that he was with the Indian Hill Rangers?
I believe he did, yes.
Okay, he did identify himself as such.
I believe he did, yes.
And he identified roads within Indian Hill, is that right?
He did testify to roads and certain businesses, at least one or two businesses within Indian Hill as well. That is correct.
How is that then different than what you described with Cincinnati police officers describing streets within Cincinnati as being sufficient?
Well, I believe it's different because I think it's common knowledge that Cincinnati is certainly located, obviously, within the city of Cincinnati, Hamilton County. I think it gets a little bit different, a little bit murkier when we're talking about these other jurisdictions that do kind of get close to bordering other counties. You know, I do believe Indian Hill is exclusively located in Hamilton County, but there's no evidence in the record that would demonstrate that. But there certainly are jurisdictions, you know, for example, Loveland. I know Loveland can be Hamilton County.
Why wouldn't the street addresses satisfy that question?
Well, because I don't, my argument is I don't think you can look at streets and say that streets standing alone are sufficient to establish venue. There are cases that this court has found that simply stating street names alone is not sufficient. Now, I know in this
Well,
case,
street names and addresses. So I can appreciate Montgomery Road runs through more than Hamilton County, but here we have like this Livingston Lodge at a specific address on Given Road. Why is that not sufficient?
because I don't think the court can look at a specific address and say, okay, that is located within Hamilton County, Ohio. There could be a, whatever, 4200 Given Road located anywhere in the United States. I just don't believe that that is sufficient. Standing alone with the testimony of an Indian Hill ranger, I don't believe that's sufficient to establish venue. You know, one of the couple cases I cited in my brief that this court has ruled on, so I cited the State v. Sullivan, where this court held that simply mentioning street names is not sufficient to establish venue. Now, I believe in that case, the opinion does state that the officer did not testify to which jurisdiction he or she worked for, so I do concede that case is a little bit different.
And here again, we have an address.
I'm sorry?
We have an address on the street. It's not just a street name.
We
It's
do have an address, but I guess my argument would be, I don't know that it makes much of a difference if we have a street name with a street number or just a street name. My argument would be that's the same thing, whether we have an address or just a street name. That still doesn't establish where the offense occurred as far as which county it occurred in.
I'm confused. Why wouldn't an address establish specifically where the offense occurred?
Because I don't see where adding a number behind an address, so 4200 Given Road is any different than Given Road, because that just, looking at that on its face, I don't see how that establishes venue. I don't see how that establishes where the offense occurred. I don't see that as any different than giving a street name. Most of the streets in Indian Hill are very small streets, and they would not cross different jurisdictions. I think just giving street names or,
But Indian Hill is located right adjacent to Claremont County.
it
yes?
is.
So, I mean, is there a question regarding the location of the lodge that was raised in the objection?
That's, I think my whole argument is because the state never established where any of this occurred, where the chase occurred, where the initial interaction occurred, or where the lodge was located. We have an address of where the lodge is. It's on Given Road in Indian Hill, but that doesn't establish that's in Hamilton County, state of Ohio.
But it's at 9300 Given Road.
It did give,
That is, would you agree that is a specific location?
I would agree with
We
that,
can put our finger on a map.
absolutely, but,
And if that's within Hampton County,
well, it likely is, but that was never established at trial, and that's my argument.
But the magistrate had this map that the magistrate relied on. And so what is the evidentiary standard there? Is it evidence that for the trial court, a venue is what? You have to prove it by?
Well, I think the map was inaccurate because the map said Cincinnati, Ohio. This did
Well,
not.
so a lot of times maps say Cincinnati, Ohio, and they are over-inclusive. But people know where locations are within Cincinnati, Ohio, and know that the suburbs of Cincinnati, Ohio are oftentimes mislabeled as Cincinnati. I mean, that's a common occurrence within the jurisdiction.
I agree, and I think that speaks to my point. The fact that this map said Cincinnati, Ohio, does not establish that it occurred in Hamilton County, because it very likely could have been Claremont County, it could have been Warren County, it could have been Butler County.
And it's just a Google map. It has no jurisdictional lines on it.
You know, I don't believe it did. I'm trying to remember it. I thought it was more of just a picture to show where it occurred. There may have been streets on it. I know in the upper left-hand corner, it did say Cincinnati, Ohio, and that is something that the magistrate and the judge relied on in finding SH, or adjudicating SH guilty here. I will just note that some of the cases that are cited in the state's briefs where this court has held that jurisdiction can be established by street names along with testimony that the officer works for a certain jurisdiction, I know at least one of those cases was reviewed under a plain error standard because the issue was not raised in the trial court level. So I think this case is slightly different because the issue was raised before the magistrate and then certainly was raised in objections as well. And I still believe that this case is different because most of those cases involve Cincinnati police officers, Cincinnati police detectives. Evidence was submitted to the Hamilton County coroner or the Hamilton County crime lab. We do not have that here. I believe this case is different. I see that I'm out of time. I will reserve my 5 minutes.
All right, thank you.
Thank you.
May it please the court, Your
Good
Honor.
morning.
Yeah, the Google map certainly was relied on substantially by the magistrate and the judge. The Google map had the specific address, 9300 Given Road. We know that the ranger Camargo was on Camargo Road, and
It's bad luck for the juvenile, huh?
yeah, kind of bad luck. And
What, how do we know that Livingston Lodge is actually in Hamilton County, though? I mean, isn't it right there? I don't know what the map shows, but isn't it right on the border?
I believe that it's pretty close to the border. I think the fact that we had the Indian Hill Ranger that was investigating this matter makes a difference. The fact that we know that the chase and any element that occurs in Hamilton County would give Hamilton County jurisdiction, and it's a felony 3.
Both Indian Hill and Montgomery could cross into Claremont County in an active chase, yes?
Oh, in any given chase it could. Yeah, that's true. I mean, I imagine any chase could cross over to different counties, but the crash occurred at 9300 Given Road, and we had an Indian Hill Ranger who was investigating that crash, which means it had to be in Hamilton County, Ohio. I may not put as much weight on Cincinnati, Ohio, but I think that does demonstrate as well. It's just one of the factors that demonstrates it occurred in Hamilton County. The other factors were, you know, the chase went past the Little Red Schoolhouse, which is in Hamilton County. The chase went past Spooky Hollow Road, which is in Hamilton County. It also went past another street. What was the name? There was another street there that they mentioned.
Like,
as well.
someone theoretically could know all these things, but if you were completely unaware of those landmarks, if you were a magistrate who had been plucked down in Hamilton County as a visiting magistrate from, you know, say Franklin County, you wouldn't know any of those things.
I think with the Google map and showing 9300 Given Road and the fact that an Indian Hill Ranger had jurisdiction over this matter would be sufficient to circumstantial evidence.
Sufficient circumstantial evidence to prove beyond a reasonable doubt.
Yes, yes. I believe the case law that we cited does support that, and Holloway deals with what police agency investigated the offense. Does that police agency have jurisdiction in a particular county? In this case, that weighs in favor of this occurred in Hamilton County. If police are driving through neighborhoods and mentioning landmarks, that's the case of State versus Walker. And we have that. We have the Little Red Schoolhouse, we have Spooky Hollow, we have other streets that we know were in Hamilton County. We know that this chase was in Hamilton County. We know that the crash occurred at 9300 Given Road in Hamilton County.
Well, but that was not testified to.
Well, there was
They didn't say 9300 Given Road in Hamilton County, Ohio.
well, the Hamilton County, Ohio was missing, but the 9300 Given Road was certainly admitted and part of the evidence. And so you're right. Again, it would have been a lot easier and there wouldn't have been any room. The magistrate was right. The fact that the prosecutor didn't say, and this occurred in Hamilton County, Ohio left some room for the defense to argue venue, but then the magistrate correctly cited the appropriate case law that you can establish venue by circumstantial evidence. And there's about 3 pieces of strong circumstantial evidence that suggests this occurred in Hamilton County, Ohio. And I do not think that was a manifest miscarriage of justice.
And the circumstantial evidence, those 3 pieces are the
Would be
address?
The address, well, that's part of the map, and I would say the police agency that investigated this offense was Indian Hill Rangers.
Well,
and then-
but so on that, isn't it true that sometimes the agencies, like in this circumstance, you're kind of right at the juncture of all of those agencies, and you're right at the juncture of Claremont County. So theoretically, sometimes those jurisdictions are overlapping on the borders,
They
which
can-
happens often in Hamilton County cases.
Right, the charge was failure to comply with an order or signal of a police officer. So let's say, just theoretically, I don't think this happened, but if the chase were, part of it occurred in Claremont County or a concurring adjacent county, you still would have jurisdiction in Hamilton County because the element of the offense occurred in Hamilton County, at least one. I mean, it's fair to comply with order or signal of a police officer, and the officer had the blue lights on when he observed the car speeding, the Audi speeding. And then the officer was in the Little Red Schoolhouse and
But so,
waited 20
but
minutes.
take my example, though.
Yeah, yeah.
Like, if you didn't know that the Little Red Schoolhouse was in Hamilton County, Indian Hill, like, if you were a completely blind magistrate, you wouldn't know that that was in Indian Hill versus Claremont County.
The only way you would know is like the police agency investigating it was a Hamilton County police agency. That's where
But
they
the
have
Little Red, a Little Red
jurisdiction.
Schoolhouse could be, look, there's nothing really that identifies the Little Red Schoolhouse as being in Hamilton County.
Just the address. The address would establish that it's in Hamilton County. You know, and I do think you can put some weight and reliability on a Google map where it says Cincinnati, Ohio, and we can take judicial notice that that's in Hamilton County, Ohio.
But sometimes suburbs outside of Hamilton County are identified as Cincinnati, Ohio. I mean, for
Yeah, the
example,
suburbs are
like
used-
Middletown is sometimes, like, sometimes people say that, you know, the vice president is from Cincinnati because he was from Middletown.
And not that he lives in East Walnut Hills or.
Right, well, it's subject to confusion.
Used to live where I live now. I don't, I mean, there's that potential there, and that's why you want the prosecutor to say it's in Hamilton County, Ohio, to remove all doubt. But the case law says you look at the police agency, we have that, Hamilton County Police Agency. All right, it's a felony, so Hamilton County would have jurisdiction over it, even if it did, for some reason, cross into other jurisdictional areas. So the fact that venue isn't established here, I think it's a stretch. And I think the case law allows when a prosecutor who does not ask that question, which I can understand how that happens sometimes in trial, you don't ask some of the very basic because it's just assumed and you should. The prosecutor should have here, didn't, but still, I believe that we have those 3 pieces of evidence. We have the Indian Hill Ranger, we have the Google Maps, it does say Cincinnati, Ohio, which is in Hamilton County, Ohio. It does give 9300 Given Road, which is the specific address. And we also have some landmarks and some roads that were in Hamilton County. And that certainly, I believe, would be sufficient circumstantial evidence to establish that this venue, that this case occurred in Hamilton County. At least certainly some element of it did, and it was properly here. You know. But that's the 3 pieces of evidence I would, direct the court to, that I think we, coupled with Holloway, coupled with Walker, and coupled with the case law that the state's permitted to, or the courts have allowed venue to be established by circumstantial evidence. And really, I don't know if I can add any more, but I'll be glad to answer any questions you have.
All right, thank you.
Well, thank you.
Your Honor, just briefly to respond, I don't disagree that if any part of this incident occurred in Hamilton County, that venue would be proper in either Hamilton County or perhaps Claremont County if it did cross the line. But this just goes back to my original argument. There is no evidence that any of this occurred in Hamilton County. Judge Nestor, as you just said, what if this was a visiting judge from another county not familiar with Cincinnati? This judge wouldn't know that the Little Red Schoolhouse or this lodge or Given Road is in Hamilton County or Claremont County or any other county.
When can a judge take judicial notice of those things? Some judges might know that immediately.
Correct, but I don't believe, and I could be wrong, I don't believe that a judge can take judicial notice of Given Road or the Little Red Schoolhouse being in Hamilton County. I think that is a fact that the state of Ohio has the burden to prove beyond a reasonable doubt at trial. I think they have the burden to prove that.
I'm sorry, the court can't take judicial notice of where an address is located on a map?
I don't believe they can take judicial notice of what county it's in.
But if the map demonstrated the county, certainly they could.
Well, if the map said the county, yes, but that's not what we have here. And furthermore, the court did not say in her opinion, or the judge in her opinion, affirming the magistrate's decision that they were taking judicial notice, at least I don't believe they did, that they were taking judicial notice that this address or any part of this offense did occur in Hamilton County. The court instead said, based on the evidence that was presented, there is sufficient circumstantial evidence that has established that this offense did occur in Hamilton County. And I would just ask the court to take a look at the record, take a look at the trial testimony, and looking at the testimony from the ranger on its face, there is nothing from the ranger's testimony that would establish this offense occurred in Hamilton County. There's no testimony that Indian Hill is a Hamilton County police agency. As we've already discussed multiple times, Indian Hill is very close to Claremont County. This is different than a case that occurs in downtown Cincinnati or that's investigated by the Cincinnati Police Department. I think that's different because we're talking about Cincinnati police. Obviously, at that point, it's Cincinnati, Ohio. The other cases that the state has cited, like I said, at least in the Walker decision, there was other evidence that established that the case occurred in Hamilton County. There was mention of Price Hill. There was mention that it had been investigated by Cincinnati Police Department. There was evidence offered that the Hamilton County coroner had tested evidence or weighed drugs or whatever it might be. So those cases, there is more evidence to establish that the offense occurred in Hamilton County. We don't have any of that here. We have a Google map that shows Cincinnati, Ohio, which, as we've already established, that doesn't mean that it's Hamilton County. It did not occur in Cincinnati. We have Indian Hill Rangers, which there's no testimony that Indian Hill is a Hamilton County police agency or that they don't investigate or that any of their jurisdiction could be in Claremont County. And then we have street names and street addresses. But once again, these businesses, these street names, these addresses, there's nothing at all contained in the record that shows that these addresses or these locations are located within Hamilton County, Ohio. I don't believe I have anything else to add unless the court has any further questions for me.
Do you know if Indian Hill is exclusively within the jurisdiction of Hamilton County?
I mean, Your Honor, I looked into the issue and based after this came up, and I believe it is, but once again, I don't think that's decisive to the issue here. I still think that the state of Ohio has the duty to prove this in the record, and I do believe that Indian Hill is exclusively located within Hamilton County, but that is not established in the record here. So, I have nothing further. Thank you for your time.
Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Wish you both a wonderful afternoon, and I don't know when the snow is coming, but hopefully we'll all be safe. Just give you a moment, Renata. All right, that concludes our hearings for this morning. Thank you so much.